Okay. All right. My name is Evan Gessner, and I'm a civil rights attorney in Lexington, South Carolina. This is my first year judging the We the People national competition. I've done the state competition for about 12 or 13 years. I'm very excited to be here, and I'm very much looking forward to your presentation.
And I am Francine Engel. I am a political scientist, and I focus on American constitutional development. And I work with the Maryland Council for Civic and History Education.
And I am Jocelyn Broman. I am a We the People alumni, competed at nationals back in 2006, like several lifetimes ago, it feels like. And I currently work on Capitol Hill for Representative Don Young.
I am Simon Crone.
Amara Termes.
Hi, I'm Rachel Jensen.
I'm Logan Lanenfeld, and our instructor is Mr. Gainey.
All right. So I was just taking some notes. Okay. So we've got Unit 3, Question 1. Now, Oliver Wendell Holmes once said, "I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review?" Go ahead and answer as soon as you're ready.
For over 200 years, the extent of federal and state power under the U.S. Constitution has remained one of the most contentious topics of American politics. In Federalist Number 78, Alexander Hamilton highlights the power of the judiciary branch, the protection of the particular rights or privileges of the people as set forth by the Constitution. To protect those rights, he proclaimed, the judiciary must be given the power of judicial review to declare as null and void laws that it deems unconstitutional. Although judicial review is not explicitly mentioned in the Constitution, the United States Supreme Court established the legitimacy of the concept when it struck down an act of Congress in the 1803 case Marbury versus Madison. By the 20th century, the courts had embraced the idea of judicial review, meaning our forefathers were correct in foreseeing that the court's ability to strike down legislation would protect the rights of the people.
Judicial review's impact on federalism can be thought of as having two statutes, vertical and horizontal. Vertically, judicial review avoids tyranny of the majority through the use of checking power of state and local government, per Madison's thinking. Horizontally, judicial review checks the power of Congress and the federal government. For example, in the case of Youngstown Sheeting Tube Company v. Sawyer, the Supreme Court limited federal power by deeming President Truman's use of presidential wartime measures to seize property unconstitutional. While judicial review has promoted both centralization and state autonomy, at different times, it has generally strengthened the federal government at the expense of the states. This means that judicial review has affected federalism more vertically than horizontally. Even when federal judges do want to invalidate federal legislation, they may hesitate to do so when the result might create a political confrontation that the courts are likely to lose. Federal judges face fewer political risk when they strike down state legislation.
Well-known American political commentator George Will once wrote, "Popularity makes no law invulnerable to invalidation. Americans accept judicial supervision of their democracy, judicial review of popular by possibly unconstitutional statutes because they know that if the Constitution is truly constitute the nation, it must trump some majority preferences." By putting it in such terms, Will makes it clear that judicial review is indeed a counter-majoritarian practice. To be counter-majoritarian is to oppose the majority. Judicial review gives the courts the ability to invalidate, overrule, or countermand laws that reflect the will of the majority. As a result, any law that the court deems unconstitutional is counter-majoritarian because it takes simple majority of the Congress for a bill to be passed in the first place. Although some disagree with the nature of judicial review, George Will justifies its value by addressing the idea of tyranny of the majority. In 2008, Judge John E. Jones III, a Republican serving on the United States District Court for the Middle District of Pennsylvania, made a similar argument stating that Article 3 of the United States Constitution itself is counter-majoritarian, adding, "The judicial branch protects the tyranny of the majority. We are a bulwark against public opinion. The judiciary is a check against the unconstitutional abuse and extension of power by the other branches of government. In other words, the judiciary branch is a counter-majoritarian by nature under the Constitution."
As judicial review is a counter-majoritarian practice, limits to the Supreme Court have been suggested, though it is not necessary to limit the Supreme Court. By its constitutional nature and intent, the judicial branch has neither force nor will, but merely judgment. The court has the ability to make its judgment, but it has no means of enforcing it. Whether the executive is obligated to enforce final court judgments has remained a matter of debate. For example, in Worcester v. Georgia, the Supreme Court overturned the conviction of a missionary living among the Cherokee Nation. Georgia's governor refused to release the missionary, vowing to defy the court's decision. Andrew Jackson supposedly remarked in response to the case, "John Marshall has made his decision, now let him enforce it." Therefore, it is unnecessary to place limits on a system that has no means of enforcement. We are now ready to take your questions.
So, how do different theories about constitutional interpretation influence judicial review?
I apologize, we didn't hear your question.
I'm sorry. So, how do different theories of constitutional interpretation influence judicial review?
So there are multiple different ways that the Constitution can be interpreted. And because of this, it's made the idea of judicial review something more of a debate. As we stated in our case, the 1803 Marbury versus Madison case specifically stated under the Constitution that it was going to be constitutional, and with the judicial branch, it made it a viable option for judicial review to be something that is theorized under the Constitution. However, if you look at it in a different sense, this could be taken away because of the different ways that the Constitution is interpreted.
Another thing with that is that judicial review and the Constitution was meant to be interpreted differently as time moved forward, and it was supposed to be a flexible document that could change over time. And so judicial review has begun to change throughout time, and the limits that have been placed on it are also changing.
What are the advantages and disadvantages of relying on the courts to resolve political issues?
A major advantage of relying on the courts is that the American people don't have to specifically rely on other branches. It gives a sense of checks and balances between the three different branches. And when it comes to the state courts rather than police or other officials enforcing these rules or laws, it always gives the individual the ability to either appeal to the court or to have a fair hearing. And it just makes everything very justified. On the contrary, a disadvantage of simply relying on the courts is that it can become too overpowering. We want to have this nice system of checks and balances between the three different branches of government. And if we simply wholly and 100% rely on the courts to do this justice for people, then we can see what we're seeing now with the injustice within the criminal justice system. And this is majorly because a lot of the power is allocated to the courts. And if we have this disadvantage, which we are seeing in present day status quo, then it just gives this injustice feeling to not only the people who are being persecuted wrongfully or people who are being persecuted when more harshly than they should have, but it gives this disproportionate nature between crimes and the repercussions that these people are paying for this crime.
The other thing, when relying solely on the Supreme Court, since they have no means of enforcement, there is no guarantee that a decision that they have made is going to be followed through with.
To add to that, I was actually going to make the same argument as why power being, or the ability of the Supreme Court or the courts in general to be able to interpret the Constitution, and why that is an advantage is because the Supreme Court has no means of enforcement, meaning that the executive branch would then have to either follow by precedent or would have to enforce the ruling of the Supreme Court. In our example, in our case in Worcester v. Georgia, Andrew Jackson made the statement that he didn't feel he had to enforce that ruling, which there's pros and cons to that ideology. However, that nature in itself, that system of checks and balance that is in place, it gives the Supreme Court that power to be able to the power of judicial review and interpret the Constitution freely without any limits because they have no means of enforcement.
So how do we know the difference between a constitutional question and a political question? Or is there a difference?
It depends on the nature of the question. Many of the questions that are proposed today in American politics are not of constitutional nature. They pertain to the political parties, they pertain to who is going to be in power of our country, president, vice president, people of congressional districts. And rather than pertaining to the Constitution itself, it pertains to the political nature because of the polarity of the arguments that we have at the moment. Furthermore, if it is going to pertain to the Constitution, normally from the questions that I've seen, it is much more based off of like more laws that are going to be proposed. For example, when it came to the issue of ERA or the Equal Rights Amendment, it majorly just showed how and when this constitutional question is going to be proposed rather than the politics. So I think it's fairly upfront.
The other thing is that a lot of these cases that do come to the Supreme Court do deal with personal rights. And the Supreme Court does have to make these judgments based on the Constitution or how times have changed, which is something that you can't base on the Constitution because when it was written and organized, the Constitution didn't include a lot of the different groups of people that we have today.
For me, I actually find it difficult to find the difference between a constitutional question and a political question, just by the nature of American politics. Just politically speaking, you can't avoid the Constitution when answering political questions.
All right. Then I have another thing. You in your statement you talked you gave George Will's assessment and then also a judge citing that the counter-majoritarian idea of the court is a good idea. Do you all agree with that? Or is there a reason why we wouldn't want that to be in our judicial system?
Well, go ahead.
So as we cited in our case, we do think, at least I think, that it is a counter-majoritarian practice in order to avoid things like tyranny of the majority. And because of this and because of what people have been inciting within the court and trying to make this not only a counter-majoritarian practice, but making it available to the people, I do believe that the jury and most of the judicial system is fairly counter-majoritarian.
We had made the argument that judicial review is counter-majoritarian simply by its nature, because for the most part, judicial review is their ability to strike down a law as being unconstitutional. And for that law to be passed in the first place, it had to be the will of the majority, which is why it is counter-majoritarian and why we agree that that is a positive thing, because it protects our nation from tyranny of the majority.
All right. Great job.
Great job. We want to recognize the students and congratulate them for their hard work and participation today.
Everyone, great job. These are not easy concepts, and I would say with a lot of them, there's not always a solid answer. As for example, what's a political question? What's a legal question? It's going to depend on a case-by-case basis, and that's an area where, in my profession, we say where reasonable minds may differ, and that you may have two very smart, very well-educated people that are going to come to the complete opposite conclusion. So I think for y'all to tackle these things at your age is really quite incredible, and I think you really did a great job.
Thank you.
Thank you, sir.
Thank you.
Yes, I would echo that. You really did a fabulous job dealing with these questions because, like you said, they are not easy. And I think you really, one of the things that you really brought out during your presentation and also during your follow-up is that, you mentioned in your statement Federalist number 78 with Hamilton saying that the court has neither force nor will, but merely judgment. And you brought up a number of examples, particularly the example by Jackson saying, the court has made its decision. Now let's see them enforce it, meaning that I am not going to enforce this decision. So I thought you did a good job kind of showing like the main limitation that is placed on the court is that just non-compliance, whether it is from a co-equal branch of government or whether it's the people themselves that are just not really complying. So if you think of prayer in school type situations, there's a number of schools that once that decision came down that they just continued to pray in school because there was really no enforcement unless somebody actually brought a case. And if everybody in the school system is all for praying, no one's going to bring a case. So it's just non-compliance and just saying, you've made your decision, but you know what? You can't enforce it. And so whether it is a president or just the American people themselves, you do see that often. And that is the main limitation that we have on the court. But I thought you did a great job and I really enjoyed hearing your presentation. Thank you so much.
Thank you.
Thank you.
Thank you.
Yeah, one of the things I really liked, particularly in your statement, is you talked about the vertical levels of power and the horizontal levels of power, and how judicial review limits power at state level in the vertical and the federal level in that horizontal way. And that was a great description of exactly what judicial review does, especially at a federal level. So I really liked that. I would have liked a little bit more about this political question versus a constitutional question. It was, you got a little bit onto the social issue, which was kind of a little bit tangential for the question, but this is something to definitely keep considering because it's one of these ideas that, like, whenever the Supreme Court hears a case about voting rights, is that a constitutional question or is that a political question? And we don't seem to have a really good way for the court to figure out what that means. It seems subjective whenever they're talking about it, and how they're dealing with different cases over time. So definitely, like, as everyone said, these are really hard questions, and I would love to hear a little bit more like opinion and then also kind of examples to kind of just support the opinions that you're giving, because they're well formed and they're well reasoned, and it always helps to build that argument a little bit more with all of this. And so, yeah, no, it was a great job and it was a good conversation. So thank you so much for your time.
Thank
Thank you.
Thank you.
Great job. Yeah.